Assalamualaikum warahmatullahi ta'ala wabarakatuh. My name is Nurul Farah Ashikin Binti Samad from class DPM 6B. Now, my friends and I would like to explain about the procedures of repossession in Hire Purchase Act 1967. Okay, so before we go through one by one, or we go through with the procedures of repossession, we have to know what is the meaning of hire purchase, what is the subject matter of hire purchase, and who is a hirer and who is an owner in a hire purchase agreement. Okay. Alright, so based on Section 2, Subsection 1 of Hire Purchase Act 1967, hire purchase agreement includes a letting of goods with an option to purchase an agreement for the purchase of goods by paying installments. Besides, according to common law, the hire purchase agreement is a contract whereby the owner lets out goods on hire and agrees that on completion of the necessary payments, the hirer may either return the goods and terminate the contract or elect to buy the goods. In other words, the hirer is given an option to purchase at the end of the duration of hire. They may decline to accept this option if he so chooses. Furthermore, in every hire purchase agreement, the hirer cannot sell the goods under hire. This is because the hirer is not the owner of the goods, and as such, he cannot pass a good title to the third parties. If he sells the goods, he may be liable to the owner for conversion. What is the subject matters of hire purchase? Okay, let's see. Okay, it refers to goods, asset or property which is to be let and then purchased by the hirer, and the goods must be in existence and definite when entering into the contract. Alright, based on the first schedule, number 1 is a mass of consumer goods, where based on Section 2 subsection 1 of the Act states that consumer goods means goods purchased for personal, family or household purposes. And the next one is motor vehicles, invalid carriages, motorcycles, motor cars including taxi cabs and hire cars, good vehicles where the maximum permissible laden weight doesn't exceed 2,540 kg, and buses including which is stage bus. In hire purchase agreement, there are several of rights and duties of hirer. Here are several rights of hirer, but in this video, we will only focus to number 7, which is rights on repossession by the owner. Alright, so before I explain what is the meaning of repossession, let's watch this video first. before I go through with the definition of repossession under the Hire Purchase Act 1967, I will explain the repossession of goods under common law. Alright, at common law, the owner has the right to recover possession of the goods if the hirer commits a breach of his obligations under the hire purchase agreement. The owner can do so by physically retaking his goods, provided he does so peacefully, or by filing an action in court. Such a drastic step taken by the owner can cause hardship to the hirer who had paid a substantial proportion of the value of the goods but who, due to financial constraints, could not continue making the monthly payments towards the end of the period of hire. The owner can, so far as the common law is concerned, repossess the goods even though there are 75% of the purchase price has been paid. As mentioned earlier, throughout the period of hire purchase, the title to the goods remains with the person from whom possession of the goods was obtained. Alright, so actually there are two situations of the hirer before the owner can repossess the goods from the hirer. Okay, based on section 16 of Hire Purchase Act 1967, the repossession can be executed provided that the installments of the hirer must not exceed 75% of the total cash price, and there had been two successive defaults of payment by the hirer, and owner has served a notice in writing in the form of fourth schedule, and the period fixed by the notice has expired, which shall not be less than 21 days after the service of the notice. Alright, so next situation is based on section 16, subsection 1A. If the payment of installments made amounts more than 75% of the total cash price of the goods, and there had been two successive defaults of payment by the hirer, and an owner shall not exercise any power of taking possession of the goods unless he has obtained an order of the court to that effect. Alright, so I'm gonna share with you for your information, in Malaysia there are several legal steps in repossession of car. The first one is pre-repossession notice. The second one is repossession of vehicle. Number 3 is post-repossession notice. Number 4 is disposal of the vehicle notice, and number 5 is selling the vehicle. So I will explain one by one after this. Alright, number 1 is pre-repossession notice. Let's say you miss your car loan payment for 2 successive. Your bank will send you and your guarantor a pre-possession notice, also known as a fourth schedule notice. The notice is intended to inform you that the bank is planning to repossess the car. You have 21 days after to sort out the matter to avoid repossession. After 14 days, the bank will send another notice as a reminder. Alright, the second one is repossession of vehicle. After that 21 days from the fourth schedule notice, the bank will have the right to repossess the car if any outstanding dues are not paid. Permit holders must ensure that they are in possession of current and valid permit during the course of carrying out the repossession work. Alright, number 3 is post-repossession notice. After repossessing your car, the bank will send you a notice to inform you that it has successfully repossessed the car. After another 21 days upon receiving this notice, you will receive another notice, the 5th schedule, which will include the amount you have due to pay the bank. The 5th schedule notice will indicate the amount you have due to pay the bank. This will typically include the missed payments and may include additional fees and charge from the bank. Number 4 is disposal of the vehicle notice. After 21 days of the 5th schedule, if you have not paid the dues, then the bank will send you another notice stating that it will be disposing of the vehicle. The disposal process may either be sold through a public auction or a private sale. And the last one is selling the vehicle. The vehicle will be sold by the bank 14 days after they served you the disposal notice. Typically, the auction price will be at a value that is lower than the current market value. The proceeds from the sale of the vehicle will be used to pay any dues to the bank. If the amount doesn't cover the dues, then you will be required to pay the rest. Alright, I think that's all from me. My friends will explain more about the procedures of repossession and the protection of hires.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Shakira binti Saharuddin from class DPM 6B. Okay, now I want to share about repossession of goods under the hire purchase. The Hire Purchase Act 1967 lays down various restrictions on the power of the owner as a means of protecting the hires. It could be argued that the Act was intended to overcome the problem posed by the strict application of common law. The relevant provisions of the said Act are Section 16 to 19. In support of these provisions, reference must also be made to the hire purchase, recovery of possessions, and maintenance of records by owner. Regulations 1976. The restrictions imposed on the owner can be neatly explained in two situations. Before and after repossessions take place. Okay, before repossessions, Section 16 sub 1 requires the owner to supply the hirer with a notice of repossessions. In the other words, notice of repossessions must be given to the hirer when goods are to be repossessed. Okay, before the owner exercises the right to repossess the goods, the owner must first assure that the balance of the loan to be paid by the hirer must be more than 1/3 of the purchase price of the goods hired. By fulfilling this requirement, only the owner would have complied with the requirement that the hirer has deferred two successive installments. Under Section 16 sub 1, the owner must serve the hirer a 21-day notice of intention to repossess in writing as set out in 4th schedule. This written notice must be serviced in compliance with Section 43 of the Act. The owner can retake possession of the goods only after the expiry of the notice period and if the overdue installments are not settled by then. In one case, Pam Brother Motors Sendia Merhat vs Lee Ai Seng, where a car was taken by the respondent on hire purchase agreement with the appellant. The respondent failed to pay the installment due and the appellant issues a notice under Section 16 sub 1. The issue was whether the notice was in fact served. The court held that Section 16 clearly specifies that the period before which the seizure can take place shall be not less than 21 days after the service of the notice. However, the date specified in the notice was 2 days short of the statutory minimum requirement and the notice was therefore bad in law even if served, and its effect was therefore null and void. In addition, before the owner take back the good, the owner must issue a final written notice in the form of a 4th schedule where the period has expired and cannot be less than 21 days. But if the hirer has paid more than one-third or 75% of the total cash of the goods, then the owner will make an appeal to the court to take over the goods. This will be a bit of a hassle. The owner of the item. Then the owner must give notice to pick up the goods after 14 days in the fourth schedule, as well as the cost of service borne by the hirer. Okay, next, for after repossession, within 21 days after repossession the goods, the owner is required under section 16 sub 3 to serve on the hirer and every guarantor of the hirer a notice in the form set out in the 5th schedule. Section 16 sub 3 is mandatory, and if the owner fails to comply with this section, the right of the owner under the hire purchase agreement will cease and terminate. This is clearly spelled under section 16 sub 6 of the Act. Therefore, it is important for the owner to serve a notice in the form as set out in the 5th schedule on the hirer and every guarantor of the hirer within 21 days after the owner has taken possession of the goods. In case Hong Leong Finance Berhad vs Rajendram, Agustin Paul J. stressed the importance for the owner to comply strictly with provisions regarding notice as set out in the 4th and 5th schedule. Then the owner must submit to the hirer a document acknowledging receipt of the goods. The document must provide a brief descriptions of the goods, date, time, and place the goods were taken back, but the owner cannot continue to sell the goods because it is an offense. The owner must send a 5th schedule notice whether the hirer when the item back or sell it to someone else within 21 days. Thank you. That's all from me.
Assalamualaikum. My name is Nurul Izzati binti Abdul Manas from DPM 6B. Today, I will explain about the right and protect of hire repossessions. First, the parties that include in a hire purchase is the owner, the hirer, and the guarantor. I will explain definition of this. First, the hirer. Hirer is a person who takes or has taken the goods from an owner under a hire purchase agreement and includes a person to whom right or liabilities under the agreement that can define in section 2 of the Hire Purchase Act. Number 2 is the owner. Owner can define in section 2 of the Hire Purchase Act. Owner as a person who lets or has let goods to a hirer under a hire purchase agreement and includes a person to whom right or liabilities under the agreement that have based by assignment or operation law. Number 3 is the guarantors. Guarantors is an owner who may require a hirer to furnish a guarantor or such number of guarantor that acceptable to the owner. At the common law, the owner has the right to recover possessions of the good if the hirer commits a breach of his obligations under the hire purchase agreements. I will continue with the right of hirer repossessions.
The right of repossession is not available to the hire vendor unless sanctioned by the court in the following case. Repossessions can happen when the hirer fails to honor the agreement. Usually occurs when a borrower or the hirer repeatedly fails to pay the monthly installment as agreed in the agreement to the owner. The right of hirer is the hirer can assign his right to another person. Example, the other persons can become the hirer instead and take over the hire purchase. Next, the rights and protections of hirer according to the Hire Purchase Act will be available once the hire purchase agreement has been concluded. Those rights and protections are derived from the implied conditions and warranty that are given to the goods hired. Example, the other person become the hire instead and take over the hire purchase. Other than that, the hirer is required to perform his obligations under the agreement. This because acceptance of delivery, payment of installments, taking reasonable care of the goods, and informing the owner of the locations of the goods when the owner makes such a request. So, the hirer breaches any of terms in the contract. The owner may have the right to terminate the agreement. The owner may even be entitled to repossess the good if the agreement contains such a term. Example of situation which can constitute breach of contract include late or non-payment installment. Next is the right for guarantor against the owner. First, the owner under this part may at any time secure his discharge by paying the amount due to the owner from the hirer. Number 2, upon such payment being made, he is entitled to, example, to sue the hirer in the name of the owner for any breach of the hirer's obligations under the hire purchase agreement, to provide the owner with a suitable indemnity for costs, or sue in his own name if he takes a legal assignment of the hire purchase debt. Next, insist upon the transfer to himself of all securities taken by the owner from the hirer to secure performance of the hirer's obligations. Number 3, the guarantor is entitled in the event of any claim being made against him by the owner on the guarantee to avail himself of any set-off. For the last part is conclusion of the hire purchase. The conclusion of the hire purchase is the owner has the right to repossession of the hire purchase good if the hirer commits a breach of his obligations under the hire purchase agreement. Example, non-payment of installment. Next, the governing statute on hire purchase in Malaysia has been around for some time, because it captures the important remedy of repossessions that the owner can exercise in a hire purchase transactions. There are gaps to fill in its provisions regarding the enforcement of this all-important remedy available to indemnify owner. There is no doubt, however, the provision of this act seem to be overprotective of the hirers. Example, the consequences of non-compliance with Section 16 subsection 3 by the owner tends to create an imbalance in the scale of justice in hire purchase agreement. This is by virtue of Section 16 subsection 6, which imposes a penalty on the owner who fails to serve a Section 16 subsection 3 notice. Other than that, the right of the owner under the hire purchase agreement will choose and determine. It will seem that the owner will not be able to enforce any remedy given to him by the agreement to recover any amount from the hirer. Because if the hirer exercises his right under this act to recover the goods repossessed by the owner, the agreement will have the same force and effect in relation to the right and liabilities of the owner and the hirer as it will have if the notice had been duly given. So, it is hereby recommended that Section 16 subsection 6 of the Act should be amended in order to remove the kind of imbalance in the scale of justice as far as hire purchase transactions are concerned. That's all from my group. Thank you.